hospitals. If you limit your right to health care, and once the right to health care is being treated in so many international instruments as being part of human right, is there any meaning in limiting the right to health care solely to government hospitals? How will you bring the private hospitals in the net of patients' right to have health care? Before going to the, we will see whether the right to health, once you give right to health care, there is a duty. On whom the duty? Can you find a doctor is having a duty to treat? Once you find Article 19 gives freedom of profession, trade and all those things, will it be unreasonable? Will it be unreasonable on part of the state to impose a duty on a doctor or a private professional? Suppose we take the public interest as being a reasonable restriction on the freedom of trade. For the time being, accept that there can be a right against even private professionals. The extent of right to health care is also debatable. To what extent do you have a right to health? In Paraman, Katara and that Masdur Samdi cases in which the court, Supreme Court has held that there is a right to health care, we finding from the fact situations, it is possible to limit the right to health care only to situations of emergency. In both cases, it was accident cases. So if you limit the right to health care to emergency situations alone, what about the majority of situations where people need health care? And in many other situations where a government can bring justice regarding Article 21 and all those things by a declaration or a governmental decision, it is not possible for the government to take a decision to provide right to health care because it involves money. So does it really mean that right to health care requires a positive action from the part of state by paying money or providing services to the patients? Again, the causes of ill health, if you analyze the causes of ill health, there are a lot of problems, environmental problems, food habits, and you see that the public health, the drainage, and even the structure of the chair you are sitting, it may also cause illness. So what is the area in which the state shall pump money? Should it only be hospitals or to some other areas? So in these areas, there are still confusion to protect the right of the people regarding health care. There is still doubtful in which area the money has to be spent. Is it merely on hospitals or like that? So this is a real problem involved in it. So when these problems are there, we find certain cases. I take one. What is the time? How much time? I will take one simple case. The material is with you in the yellow book. In ex parte B's case, in Cambridge Health Area Authority ex parte B. In that case, a girl who was about 10 years was having leukemia. The hospital authorities gave 2 times the blood transfusion, chemotherapy, and also 1 time bone marrow transplant. Still, she was not cured. After 10 months, again the problem arose, and the doctor said there is no need and further providing a bone marrow transplant. It is enough to provide palliative care or pain-removing care. That will be enough. But the parents of this girl, they were really poor. They consulted a doctor outside, and that doctor advised go for a bone marrow transplant. And if the girl requests that bone marrow transplant, the doctors in the government hospital said no. So this person really asked for the government, the hospital authorities, to pay for it. He is ready to do it in an outside hospital. So the matter came before the court when the parents were rejected a financial help from the hospital, in which actually there is a provision in the hospital rules. If it is not available in the hospital, let it be done outside. The hospital will pay for it. When it was rejected, the parents approached the court. The court said, the court took it, the decision of the hospital authorities merely as an administrative decision. So while reviewing an administrative decision, the courts looked into one fact. Was the decision of the hospital authorities in not providing the financial help, was it reasonable or not? Applying the well-known Wednesbury rule, the court said the team of doctors treating the child said no to bone marrow transplantation. So that decision is not unreasonable, and we go by the decision of the hospital. Now, if you consider the case above an administrative decision as one involving the health care, which is said to be the human rights part of it, element of it, the court could decide in a different way, but it was not done. So the approach of the court in treating a particular situation, either as a mere administrative decision or a health care situation, the decision could have been different. And you may also know that this ex parte bis case was in 1995 or so. But after 1998 and 2000, you find the Human Rights Act became a law in England. We do not know how the courts will decide. But the approach of the courts, at least in one situation, is that they treat these things as merely an administrative decision and not looking at the other side of the situations. But if you come to India, we find a decision, Mohinder Singh Chawla, where we find that the government has allowed some money, where the rule was that no money will be paid regarding room rent and all those things. The court asked for a reimbursement purposes, room rent has to be paid. So there is some decisions in India we find shortage of money cannot be a problem, and that we get a support from the two cases. But a lot of umpteen number of cases are there. Ratlam municipality's case and the other case from Himachal Pradesh, Umed Ram's case, where the court rejected the arguments of the state of paucity of funds in providing 21 rights. So Indian courts, we can find some rescue if you find the instance of Umed Ram and Ratlam. The paucity of funds will not be a problem. But if you go to the situations in Canada or South Africa, I got those cases in the booklet, you find it is a very pity situation. The general position from the attitude of the courts is no, because it is not, there are also arguments why a no to a particular case. Because if you give a lot of money to a particular patient, what about other patients who are in need of money? So considering the interests of the other patients who are waiting, who are in the queue for financial help from the government, it is very difficult for the court to say yes to this particular case and what about the next case. So the courts in that respect just follow the administrative decision once it is found to be reasonable. Okay, that's all. Thank you.
Thank you, Doctor, for enlightening on this expenditure on the and hurdle for getting this right to health like that. And one more area again we are concerned with, that is an expenditure on the exchequer. That's the prisoners' rights and also the jail reforms. I request Ms. Radhika Pai and Ms. Neela Hegde, a joint venture for this prisoners' rights and jail reforms. Please.
Thank you, sir. Good afternoon. Our paper today is a combined effort to look into insights of relation between human rights and prisoners, and consequent development of concept in the form of jail reforms. We've read Japanese executions in a recent newspaper where in Japan, death penalty to convicts are executed suddenly and without warning. This is a violation of International Covenant on Civil and Political Rights, which legally obligates state parties to ensure strict safeguards while applying death penalty, and by reporting, it's just trying to confirm these standards. But in actual, it is widely accepted principles that executions cannot be carried out in secret and without warning, as it would amount to inhuman punishment and treatment of prisoners. This is one aspect of human rights of the prisoners. Human rights violations are a subject grave and thoughtful and ever increasing in nature and scope as civilization is developing. So human rights today has gained a multi-dimensional approach. Even the layman is speaking of human rights because he recognizes that he is a human being. I'll take the definition of human rights. They are basic, universal, inalienable rights and freedoms available to all human beings because they are human beings. So even the prisoners have the basic rights of right to life and liberty, freedom of thought and expression, and equality before law. Now the question arises, who is a prisoner? In common parlance, a prisoner is a person incarcerated in a prison or jail or similar facility, prisoner of war, political prisoner, or the one who is held for ransom, hostage, etc. But in legal parlance, we have to restrict prisoner to a person held in custody, captivity, or a condition of forcible restraint by state for two reasons. One is for trial, and the second is for serving prison sentence. Now, why are the human rights provided to prisoners? He has violated somebody else's right. So he should not have the right, human right available to others. This is the misconception held by many. But in actual, human rights are provided for two reasons. One, because just because he's a prisoner, he does not cease to be a citizen. The second, prisoners go to prison just as a punishment and not for punishment. Sentence should be carried out according to the court's order. These are the two reasons why human rights is provided to prisoners. Under international scenario, prisoners' human right is classified as civil rights. It means that it is the most basic and fundamental of all human rights. Two international covenants speak basically about human rights of prisoners. This is United Nations Covenant on Civil and Political Rights and Universal Declaration of Human Rights. Now we move on to Indian scenario. I have tried to divide this into three aspects. That's legal framework, constitutional interpretations, and judicial response. Under legal framework, there have been set of acts which are being provided, which provide human rights to prisoners. They are as in the slide. Next is the constitutional provision. This includes right to life, freedom of speech and expression, right to equality, religion, and writs of habeas corpus. Major concern here is about right to life. Right to life can be interpreted as right to protection from torture, right to privacy, right against solitary confinement, right against handcuffing, right to speedy trial, right to free legal aid, right against delayed execution, right to health, and right to development. No other fundamental right has received such expansive interpretation as right to life. However, it is a matter of deep regret that it is the very right which is violated most. The next is equality. Prisons prisoners inside prison should be treated equally. This is right to equality provided to prisoners. And the next is freedom of speech and expression. Under this, I would like to quote one instance where a prisoner was allowed to publish his book, a scientific book, even though he was a detainee. So, by this case, court interpreted prisoner's right to include freedom of speech and expression. Next, I'll speak about judicial response. In sphere of judicial response, there have been innumerable judgments which pertain to prisoner's right. And these highlight mostly on three things. One is about the prison conditions. The second is interpretation of constitution to include fundamental rights in the basic human rights of the prisoners. And the third is about the treatment of prisoners. It has highly given judgments in these matters. Then, to conclude, I would say terrorism has created tendency upon government to override human rights. Judicial concern of making available the human rights to prisoners is not sufficient. There must be a change in executive and administrative behavior. Lastly, the present system of police and jail administration needs a tremendous change. And this can be done only by jail reforms, whose more insights will be given by Srimati Neela.
Good afternoon, everybody. I would like to speak on prison reforms in India. Now, the British had taken several measures to effect prison reforms, but I'll restrict my lecture to prison reforms in India after independence. Now, the report of the All India Committee on Jail Reforms, chaired by Justice A.N. Mulla, had observed that the prison administration in India has been on and off a subject of criticism in the press, the parliament and the judiciary. Overcrowded prisons, prolonged detention of under-trial prisoners, unsatisfactory living conditions, lack of treatment programs, and allegations of an indifferent and even inhuman approach in the prison staff have repeatedly attracted the attention of critics all over the world. Now, the Mulla Committee had noted that a majority of persons lodged in prisons consisted of people belonging to the underprivileged sections of the society, and that the majority of the prison population was from a rural and agricultural background. First offenders involved in technical or minor violations of law accounted for a large number of prisoners. The Mulla Committee examined all aspects of prison administration and made wide-ranging recommendations, which if implemented would go a long way to make prison administration efficient, humane and professional. The recommendations of the Mulla Committee touched upon legislative, operational, security aspects, besides matters like classification of prisoners, living conditions in prison, medical and psychiatric services, treatment programs, vocational training for prison inmates, problems related to under-trials and other unconvicted persons, problems of women prisoners, etc. The report laid emphasis on the management of prisons to be entrusted to a cadre of professionals. The National Police Commission also looked into issues like arrest, detention in custody, interrogation of women, and delay in investigation, which contributes to the undue detention in custody of non-convicted persons. Besides highlighting the need to adhere to provisions of law, it made wide-ranging suggestions to amend laws and procedures to cut down on delays at the investigation and trial stages and avoid custodial violence and lockup illegalities, to inspect police lockups and report on them. Next, the report of the National Commission for Women on Custodial Justice for Women made its attention. The Krishna Iyer Committee forms the basis of this report. The salient features of this report are: women prisoners, like men, should be informed of their rights under the law. Women constables should conduct searches. Medical checkups for women prisoners or under trials should be done by women doctors as soon as they come to the prison. women prisoners should be allowed to contact their families and communicate with their lawyers, women social workers and voluntary organizations. Women prisoners should be allowed to keep their children with them. Voluntary organizations of women should be encouraged to be associated with women prisoners. Separate jails should be provided for women. Special prosecution officers should be made available to present the case of women prisoners. The National Human Rights Commission also has made certain recommendations. It has expressed a deep concern about the appalling conditions of overcrowding, lack of sanitation, poor medical facilities, inadequate diet, and in most of the in most of the jails of the country. These serious deficiencies are compounded by unconscionable delays in the disposal of cases for various reasons and mismanagement in the administration of jails, all of which need to be remedied. The right of the arrested persons to request that a friend, I'll cut short it, she has already discussed about that. The Mullah Committee, the National Police Commission, Justice Krishna Iyer Committee and the National Human Rights Commission have made numerous valuable recommendations to bring about not only improvements and reform in the jail administration, but in the entire criminal justice system itself. Unless there is a comprehensive reform of the criminal justice system in the country, there is unlikely to be a decisive change. Various commissions and committees have examined the problems relating to different elements of criminal justice system, but what is required is a detailed look at the criminal justice system as a whole. Perhaps this matter could be remitted to the Criminal Justice Commission, drawing upon talents from all the branches of the criminal justice system. Such an effort is long overdue and would be an essential and urgent step towards the reform of vital spheres of public administration affecting human rights and human dignity. Now I'll come to the recommendations made by various commissions. I'll cut short everything and briefly I'll put one by one. Overcrowding. The first and the major problem in the jails is overcrowding. Now, to give an example, in Delhi, Tihar jail holds about 9,000 prisoners as against the stipulated capacity of 2,200. The reasons for this overcrowding in the jail are many. Inordinate delays in trials result in many under trials having to be detained in jail for unduly long periods. In many cases, prisoners who are facing charges of grave professional violent crimes are outnumbered by others like suspected drug offenders, ticketless travelers, railway alarm chain pullers, and a variety of others who have technically violated law. Many of them are in jail because they could not pay the fines imposed on them by the courts. In some cases, prisoners prefer to continue in jails because they cannot afford even a single meal a day outside. And there are prisoners who prefer to spend a couple of months in a jail then to pay maintenance to their wives as ordered by the courts. Urgent solutions have to be found for reducing delays in trials. The National Police Commission pointed out that 60% of all the arrests were either unnecessary or unjustified. This has resulted in overcrowding and accounts for 43.2% of the expenditure of the jails, which could have been avoided. Therefore, restraint by police in resorting to unwarranted arrests by following the guidelines laid down by the Supreme Court would go a long way in reducing overcrowding in the jails. Next is delay in trials. Trials delayed in the courts has assumed very serious proportions. The pitiable plight of under trials in Bihar jails, primarily due to enormous congestions in the courts, brought to light by KF Rustamji, resulted in the matter being noted by the Supreme Court. The National Human Rights Commission has also taken note of the problem of delay affecting under trials, including about 3,300 foreign nationals in various jails in the country. No one aspect of prison administration has affected the human rights of prisoners as delays in trial for which the police, judiciary and the legal professionals are all to blame. It is only by the joint efforts of all these links that there can be any semblance of improvement, that the under trials account for over 50% of the total jail population. Delay commences at the investigation stage itself. In many cases, charge sheets are filed by the police very late, leading to a long chain reaction. The next bottleneck occurs in the course of service of summons to witness, often due to the collaboration between the process server, police and the witnesses. This stage of judicial process has lent itself to corrupt practices, which need to be set right. However, maximum delay takes place when evidence is to be recorded. In some cases, it has taken more than 8 years to examine witnesses and record evidence. Official witnesses, lawyers, and public witnesses can attribute this delay to procedural complexities and absenteeism in one form or the other. Defense and prosecution lawyers make their own contribution to the prolongation of trials. The situation has further deteriorated after the separation of prosecution from the police, leading to dilution in accountability and less effectiveness.